Claire Corey. I represent District 42 in the northwestern corner of Grand Forks. Here today to introduce Senate Bill 2383. This topic obviously has been a big topic for many years in the legislature, but this bill was a product of several constituents who came to me and brought this problem forward and worked on the bill together. And so I probably wouldn't be the best person to answer any questions, but I have some of my constituents made the trip to testify on the bill, and so any questions about it, I would defer to that. But this is the co-parenting topic that we all know.
Any questions for Senator Corey? Okay, I guess not. Who else would like to come and testify in favor of 2383? 9-page bill.
Madam Chair, Senators of the Judiciary Committee, my name is Derek Sherwood, and I'm here to testify in full support of Senate Bill 2383. I would like to discuss family law. I am here today in support of this bill because it is a much-needed change for the state of North Dakota. This bill is needed because our current laws force parents into a competition for custody for minor children simply by utilizing one word: best. For example, let's say today we are here to determine who is the best senator. Senator A may believe, we'll go with that one. Senator A may believe that they are the best because they have a vast experience in the legislature. Senator B may believe that they are the best because they have fresh new ideas. Now prove to me who is the best. What happened here is we created an unnecessary competition. The fact is that while this hypothetical situation is not real, this is what happens in our family courts across the state of North Dakota. As senators, you all come into session on equal ground simply by holding the title of senator and being duly elected to your position. No voice is less powerful than the other, and all votes are the same. In family court, you are required to prove to a judge in a child custody case that you are better than the other parent. We need a standard in this state that to place every individual, to include the children, on equal ground under the law. While the Constitution of the United States grants equal protection under the law, this standard is widely ignored in divorce cases simply because it is a civil, not a criminal action. Troxel versus Granville and other United States Supreme Court decisions have made it clear that parenting is a fundamental right guaranteed by the 14th Amendment, for example, to exercise care, custody, and control of their children. Also, it is a First Amendment right, the right to familiar association, for example, private speech, to do homework together, to pray together, and lead by example on a regular basis. This also means this right is further protected under Article 1 of the North Dakota Constitution. It now begs the question, how is a parent able to parent when the court allows the children to move 1,500 miles away from parent A and only granting parent A 15% of the year to have time with the children, while parent B, being the custodial parent, is granted 85% of the year and has the authority to determine when parent A can exercise their parenting time. With those numbers, parent A is nothing more than a visitor. This is exactly what happened in my divorce case. Simply due to my job that required me to move here, a district judge determined there is no community support and therefore the children will be allowed to move to a place where they never lived. Senate Bill 2383 corrects these issues by establishing the rights of all parties involved to include the children, and mandating that each parent is fit unless has been deemed unfit. This determination of fitness and equal protection aligns North Dakota with the Troxel standard. Additionally, this bill corrects vague language within the best interest factors. Specifically, this eliminates the moral fitness clause, commonly referred to as Factor F. State of North Dakota versus Halbach states vague laws may trap the innocent because they fail to provide adequate warning of what conduct is prohibited, and they may result in arbitrary and discriminatory application because a vague law delegates basic policy matters to those who apply the law, allowing the law to be applied on an ad hoc and subjective basis. The vagueness of this factor is morality. What is defined as moral? As the senator from this state said, it is not the job of the government to regulate morality. Yet the regulation of this morality is codified in our law. This codification allows a judge who may not agree with a person's belief to be determined immoral and not be awarded custody of their children, when that person's morals and ethics have no effect on the parent's ability to raise a child simply because a judge has a different opinion. Furthermore, this action reins in the unchecked power of the courts that have been legislating from the bench. In 2021, the North Dakota Supreme Court explained the word necessary in Slappy versus Slappy. I emphasize that the court expanded the requirement for a modification of custody to demonstrate a change in circumstance that adversely affected the child's best interest, and that change is required to include circumstances where there has been a general decline in the condition of the child. Therefore, the court, again, emphasizing the court, made it clear that simply by proving your circumstances as a party is not sufficient to modify custody or parenting time. Neither will a general decline of the primary parent's circumstances. None of this is written into the law. By doing this, the court has usurped the power of the legislative body. Senate Bill 2383 will ensure that the courts are bound by an equality standard, not an equitable one. Equality and equitability are two completely different things. Also, if passed, this bill will update our standards in North Dakota to a modern-day standard that takes into consideration the elevated divorce and children born out of wedlock statistics. While it is understood and agreed that the family unit is the cornerstone to our great country and state, we must face a fact that 50% of all marriages end in divorce, and most divorces occur within the first 5 years and the 15th to 20th years of marriage. According to these statistics, also 65% of the children are born within the first 5 years of marriage. These statistics also do not include the 40% of children who are born out of wedlock, and half of these occurring within cohabitating. The dynamics show that children are more than likely to be involved with a divorce-type custody arrangement at some point in their life. By ensuring that parents are fit unless deemed unfit, we can place children in a more dynamic home life situation where they can be raised by both parents equally under the law. Lastly, this bill protects our military members across the state. Provisions listed in Section 5, Number 3 allow a military member who is deployed to make up lost time, especially if they are inherently unable to execute parenting time due to military service. We must consider that 80% of all military marriages end in divorce, with only 0.04% of the military member retaining primary custody. By granting equal division of the time, or at minimum 100 days a year, or approximately 30%, it will ensure proper parenting time is guaranteed for our service members unless they are deemed unfit. In conclusion, for the above listed reasons, now is the time to pass this bill. We will only make the state of North Dakota better by aligning us with current guidance, update us to a modern-day standard, and protect our service members. Not only will it make better for parents, but the future of the state of North Dakota, which is the children. I thank you all for hearing this testimony and respectfully request that you vote a do pass recommendation for this bill. And at this time, I will open myself for any questions at this point.
You mentioned under military duty, you mentioned 100 days. Where is that spelled out in the bill?
If you, I can pull the bill up for you. It's in Section 5. I believe I testified in Section 5, Number 3.
Right. I don't see anything about 100 days or anything.
Okay, that would be a different portion of the bill. If we look at a minimum 100 days a year, that would be under Section 3, nope, sorry, 4. There was a portion in there regarding a minimum 100 days a year. I'm sorry, I can't find it right now on the spot, but it is in, I do know for a fact that is in there.
It's in the bill somewhere, all right. Any questions for Mr. Sherwood?
Madam Chair,
Senator Bromberger?
I just found it. It's on page 5, line 19 through 24.
Okay, I see it. At least 100 days per year. Thank you. Any questions for Mr. Sherwood? Thank you, sir.
Thank you.
Any other testimony in support of 2383?
Thank you, committee members. My name is Mark Ludwig. I'm here from St. Louis, Missouri, where it was 71 degrees today, and I was told that this would be a fun city to come to. Was basically talked into coming by Derek just to tell a little bit of my story. I'm just a dad who wanted time with my son's Uber driver. Shortly after my son was born, there was some question of paternity, and in order to avoid a DNA test, my son was taken without my knowledge. I went 204 days without seeing him, not knowing if I would ever see him again. And after I tracked him down, I just assumed that I would get 50-50 since I was the dad. And I got relegated to even less than an every other weekend visitor because my son hadn't had much time around me. And they said that he needed to be reacclimated with me before that I could get the extra time. My story went viral. I'm pretty well known in Missouri. My story went viral, and as a result of that, I'll give you some statistics, and not to point light out on me, because it's more about the message than the messenger, but just to put things into perspective. My story's been viewed over 120 million times on social media. I've got over 1 million followers as a result of the story that I had. Been on 320 TV and radio interviews. This year I spoke for the National Association of Christian Lawmakers. I now serve on the Phyllis Schlafly Eagle Council, the ALEC HHS Model Policy Task Force, and this year was asked by the Trump team to be a fatherhood advisor on their policy council. And as I said, it's not about me, but it's to give an idea of how prevalent this is, and obviously the issue resonates with a lot of people all across the country. But it's not about the mother, it's not about the father, it's about the child. And I'll fight just as hard for a mother as I will for the father, because the child needs two inputs. I believe opposites are attracted for a reason. Each has a strength and each has a weakness. Normally, fathers tend to be more the disciplinarian, mothers tend to be more the nurturer. If you rip one of those parents out of a child's life, it's a very unhealthy way, an unbalanced way to raise a child. Unfortunately, what I get with a lot of my followers is they tell me, you know what, Mark, I didn't hate my ex near as much until I went into my first family law attorney's office. And this is no condemnation of family law attorneys if they're on here, very sincerely. But a family law attorney, their responsibility is to their client. And their client is usually either the father or the mother. The client isn't the child, so they're doing their job. They're representing the client. But as an attorney, their responsibility by fighting for that is to tell them, look, in our state, you're not going to get 50-50, so I need you to help me dig up dirt on why you're the better parent. And as Derek said, I don't think there is a better parent. You know, my son's mother and I do not agree on a lot, okay? But that's still his mom. And she adds value to my son's life in a way that I don't add value. And here's a couple at the most vulnerable point of their relationship where they need to learn to co-parent together, and instead they're being riled up into this adversarial relationship of digging up dirt on the past. If any of you have been through a divorce, when you think of your ex and the worst times of your divorce, do you think of co-parenting real nice with that person? Probably not. And so as a result, we're digging up the worst of the worst. And what ends up happening from the child's perspective, they have a dual trauma. Trauma number one, mom and dad aren't together. They don't know how to articulate that they're confused, but it's very confusing for the child who grew up with both parents. But trauma number two is the bad one. Trauma number two is, why is one parent the superior parent and one is the inferior parent? Why does one parent have to ask permission to vary the schedule? Why do I only get to be a guest or a visitor in one parent's bedroom 4 overnights a month or every other weekend? Are they not significant? And what ends up happening is down the road, when there's discipline problems, because usually it's the father, but when there's discipline problems, it's very hard for a father who's been conditioned to be treated as a visitor to all of a sudden be able to take responsibilities as the disciplinarian. And that's why prevalent all across the country, incarceration rates, violent crime rates, behavioral problems, drug use, high school dropout rates, teen pregnancies, the one common ingredient, they grew up without a dad in 71 to 94% of those cases. And yes, there's some dads that walk away, but we don't push the other good ones out. If somebody gets a DWI in this town, you don't take everyone's driver's license away and say, prove again that you should be a good driver. No, you take, everyone is assumed to be a fit, willing, and able driver unless proven otherwise. Well, based on the fact that you had a child, you should be presumed to be a good parent unless proven otherwise. We don't have policy by anecdote where we find the one extreme case, which does happen. There are cases out there. But imagine if we could clear the courtrooms of all the cases that don't need to be there, and now judges have the time to focus on the cases that need to be there. So I just ask for you to take consideration of this, because I'll tell you what, there's a lot of kids in North Dakota right now that I promise you tonight are going to come home from school and wish they could see their dad when they came home from school and tell them about their homework too. So thanks so much. I appreciate it. And if you have any questions.
Any questions for Mr. Ludwig? Senator Paulson.
Thank you, Madam Chair. Mr. Ludwig, I just don't see your testimony online. Can we get a copy of that for our intern?
Yeah, I can. I just hand wrote. I'm an Uber driver, so I literally just hand wrote notes. But I can get a copy to the senator, and I'll get them for you.
Thank you.
Any other questions? Thank you, sir. Any other testimony in support of 2383?
So I'm gonna just read from my paper, and I'm a little nervous. I'm not really good at public speaking. I'm from the South, so if I go too fast, just say, hey, stop, we don't understand y'all, so just chill. So Madam Chair, Senators of the committee, my name is Phyllis Lewis, and I am here to support Senate Bill 2383. This bill is for North Dakota. Bill 2383 allows children to experience what I call the orange effect. You may ask yourselves, what is the orange effect? Allow me to explain. The orange effect is children who get to have both mom and dad in their lives as close to 50-50 as possible. If we continue the trend to have red house, yellow house, children often do not get to experience. Sorry, I'm not really sure why. This is the first time I've cried over this bill. Children often do not get to experience the orange house, hence the red and yellow make orange. While these colors are beautiful in their own ways, each having an orange or an orange-like house would allow them, when they're blended, they become something different, something brighter, and something that allows children to thrive in each environment as if they were living in one home. They will get to experience love, traditions, and they get to design memories that last a lifetime with both parents. If you are concerned abusers or people who place children in harm's way would be protected, they are not. I can assure you this bill will do the exact opposite. The provision this bill has will activate, and let me highlight the word activate, the best interest factors, if and only if there's unmistakable evidence resulting in convictions of domestic violence or other situations that would bring emotional and physical harm to children. Let's remember that just because mom and dad didn't get along, it doesn't mean that children have to suffer by not having one parent in their lives equally. I am the yellow house. I didn't grow up with a dad. And I'm 40 years old, and I stand here before you to let you know that it still hurts. I don't know his favorite color. I don't know his favorite dish. And unfortunately, when I was 13, he died. And I'll never have those answers. And this is all a result of family courts and how they operate. The current law does not allow for close to 50-50 as possible. And this has created government sanctioned alienation. Now, I want to point out there are clear differences between child custody cases where both parents have clean records and considered good parents. And you have cases where you need something activated because one parent has caused harm to a child. Listed in Section 3, Number 2, it protects children from domestic violence. Let me give you a real example. Before filing for my divorce in 2022, there was what I call a night of terror on August 23rd of that year. My then husband held me and our 2 children against our will. I was beaten, I was choked, and I was struck with objects multiple times for roughly 2 hours. All of this was done in the presence of the children. He also threatened their lives many times that night. My now ex-husband was convicted of domestic violence. And again, I highlight that word convicted, not just against myself, but of the children. If this bill passes, situations like mine will again trigger those provisions that will protect children. In Section 3(2)D and in Section 3, Number 2E, and it will enforce what we use now, known as the best interest factors. But note, again, the word convicted. This means there was a fair review to which an overwhelming evidence from myself and the children played in his conviction. This bill would protect the children more than the current laws do. This bill follows guidelines within the Constitution of the United States of America. You ask yourself about cases of parents where these may not be relevant at first, but they may still exist. But that's why we have these other entities to help us with these things. There are things that parents have gone through, such as parental capacities, drug alcohol dependency tests, and even with some of these parents pass these with flying colors, they are still ripped from their children's lives because it's nothing but a competition, and that has to stop. Otherwise, you're going to have somebody else, 40 years old, sitting up here shaking because she wants to call her dad after this since they did the job. Now here comes a bold but true statement. Under the current laws for best interests, I could have a child with anyone in this room, and all I have to do is say I'm afraid. And it could be game over for your parenting time. All of this is in the best interest factors, where all I'm required to do is show evidence. But let's remember that evidence is not a legal standard, and it's extremely vague. And just because I am fearful for an undefined thing does not mean you deserve not to be in your child's life or have your parenting time limited. We are setting our children up for failure. And when there are good limits on parents, this bill is not just for parents of North Dakota, but more so for the children of North Dakota. They are what matter. They are our citizens in the future of the state, and we are responsible for protecting their rights too, as they are not able to vote. We need to preserve their rights to life, liberty, and the pursuit of happiness, which are protected by Senate Bill 2383. In conclusion, I'm sure many of you have driven out of state, and when you return, I wonder if you've ever noticed what the sign says. It says, "We are welcome to North Dakota, be legendary." Let us be the state that sets the standard for shared parenting. And it was also acknowledged to me that even in our courtroom where we've all walked these walls today, it still says it on the postcard where we are today, North Dakota, be legendary. I do appreciate y'all taking the time to speak with me. And if you have any questions, I will answer.
Any questions for Ms. Lewis? Thank you, ma'am. Oh, Senator Ludwig.
Madam Chairman and Ms. Lewis, how many states have some sort of a shared parenting law right now?
As far as I know, that we've maybe or roughly about 30. I know that Mark would be the better person to answer. Is it now 5? I thought okay. So we're working in but currently 5.
Okay. And is it 50-50?
50-50 for 5. Yes.
Okay, thank you.
Yeah.
Any other testimony in support of 2383? Any testimony in opposition to 2383?
Hello, Chairwoman Larson and members of the Senate Judiciary Committee. My name is Seth O'Neill, and I'm here representing the North Dakota Domestic and Sexual Violence Coalition in opposition to 2283. And our agency represents the 19 victim service provider agencies across the state. And just for my own background, I'm an attorney as well as a social worker and have some experience with family law, but also child protection as well. So this bill would make substantial changes to the family law provisions of the North Dakota Century Code. As you had heard, presently when there's a custody action in court, the court must consider the best interests of the child when deciding parenting responsibility. This bill would change that by presuming that equal decision-making responsibility is in the best interests of all children. Although this presumption may be rebutted, some of the rebuttal provisions are pretty cumbersome. In addition, the provision regarding domestic violence states that a court may not consider a domestic violence protection order as evidence that a party has committed domestic violence. So a court looking at a family law case isn't allowed to say, oh, this person has a protection order against them, therefore they committed domestic violence. They're not allowed to consider that from a different court or from the same court, just a different proceeding. Also, if the court determines that equal residential responsibility would be detrimental to a child due to the parents living 50 miles apart, the parent who does not have primary residential responsibility must be awarded at least 100 days of parenting time. This provision, I think, is unworkable and does not allow a court to consider what is best for the child to craft an arrangement. Right now, courts are given a lot of discretion to look at each facts of a case and come up with an arrangement that's in the best interest of the child. This is kind of taking that discretion away from the court. This bill would also modify the best interest factors that would be used if the presumption is properly rebutted. So the best interest factor regarding domestic violence would be severely weakened to only apply in cases of serious bodily injury. In addition, the individual who committed the violence must have been convicted of the crime. The provision also doesn't say what crime they need to be convicted for. So it's not clear if it's a certain crime that they need to be convicted for or just any crime related to that instance. It's not clear because, as we know, an instance of domestic violence, someone might not always be tried and convicted for domestic violence and might be, aggravated assault or simple assault or something like that. So that part just is not clear. It also just removes a lot of protections for kids when that factor is severely limited. So I put in here, if someone was convicted of trespassing related to an instance of domestic violence, does that fit within the best interest factor? We don't know because the bill doesn't say that, doesn't make it clear. Finally, this bill would not allow a parent with equal residential responsibility to relocate to another state without the consent of the other parent. Presently, a court may allow a parent to relocate to another state without the permission of the other parent. Removing this provision would not prohibit the court from intervening, would prohibit the court from intervening in these situations altogether. So if there's a parent living in Fargo and they would like to move to Moorhead and the other parent doesn't consent, they can't make that move to Moorhead. Due to these reasons and many others, I would strongly encourage the committee to give Senate Bill 2383 a do not pass recommendations. And I'm happy to answer any questions.
Any questions for Mr. O'Neill? Senator Bromberger.
Thank you, Madam Chair. Mr. O'Neill, can you, do you have an idea what percentage of domestic violence cases actually make it to court?
Chairwoman Larson and Senator Bromberger, when you say to court, are you referring, what type of court proceeding are you referring to?
I guess what I'm saying is how many domestic, when someone is, say, has an incident that's related to a domestic violence, how many of those cases that are involve law enforcement actually get a conviction in the criminal court for domestic violence?
Chairwoman Larson and Senator Bromberger, I would say I don't have a specific number, but it's a small percentage that result in conviction. I think oftentimes these cases involve two people that it's behind closed doors, and so it's very difficult to get a conviction. We have quite a bit of success in getting protection orders for people to make sure the victim is protected, but getting convictions are getting exceedingly difficult.
Continue.
Thank you, Madam Chair. So this exempts domestic violence, but this also doesn't take into consideration for protection orders, does it? Does this law that you see?
Chairwoman Larson and Senator Bromberger, it does not take into account a protection order, so it does have a provision related to domestic violence on page 3, starting at line 10. But it specifically says on line 13, a domestic violence protection order that has been issued by a court or magistrate may not be considered by the court as evidence of domestic violence. And that is a big concern with this bill, is that a domestic violence protection order is a specific proceeding to find whether or not there's domestic violence. So that court is in the best place to judge whether or not there was domestic violence. Thank you.
Senator Corey.
Thank you, Madam Chair. Mr. O'Neill, so touching on the 100-day part in your testimony, does a wording 100 days mean that it all has to be used?
Chairwoman Larson and Senator Corey, that is a good question. Can you point me to that section of the bill?
Page 5, line 19 through 24.
Chairwoman Larson and Senator Corey, I guess it doesn't specifically say that the parenting time must be used, but it is kind of presumed that if the parent wants that time, that they will be get it, and so that's what the concern is with there. There's no exceptions to that 100-day provision.
Senator Ludwig.
Madam Chairman and Mr. O'Neill, how long have you been involved with the work that you do now today with these court cases and the problems we have with the divided families?
Chairwoman Larson, Senator Ludwig, over 10 years.
And do you think that what we are doing today works well?
Chairwoman Larson and Senator Ludwig, I would say that these situations are very complex. I think the courts in North Dakota do a fine job, but it's very difficult to legislate these issues.
I get that. Madam Chairman, if I can
Continue.
continue. I get that they are hard to legislate, but do you think that our system is working properly the way that it should, or do we have room to improve?
Chairman Larson, Senator Ludwig, I do think our system is working properly. I would say access to attorneys probably makes this system difficult. It's very difficult to be pro se in a family law matter, so I would say that is an area of improvement. But I think the best interest factors work as they should.
Thank you.
Thank you.
Any other questions for Mr. O'Neill? Senator Castaneda.
Madam Chair, Mr. O'Neill, do you think that, based on current law, the judges that have to, come up with these things, and I can't imagine how they do it day to day, but, it's tough. But do you think that they start with a goal of trying to provide 50-50 parenting, and from there they might move a little left, a little right based on, so many circumstances are unique to every case, but would I be right or wrong in saying that their goal is to start at 50-50 and after looking at everything, stay at 50-50 for the max, as much as possible? And do you think they do that? Yes, and if so, why? And if they don't, why? Possibly because the law doesn't allow them to do? That's my question.
Chairwoman Larson and Senator, I certainly can't speak for the courts or the judges, but the law requires that they look for the best interests of the child. And so I think that's what the courts do, is look what's best for each child individually when they're deciding these matters.
Any other questions? Thank you.
Thank you.
Any other testimony in opposition to 2383? Thank you.
Madam Chair Larson, members of Senate Judiciary, for the record, Jackie Hall. Today I am here as a constituent of Mandan, North Dakota, not as a lobbyist. In 2013, my ex-husband and I divorced. Our children were 2, 4, and 6 at the time. My ex-husband did not have a permanent place to live, and to be honest, the knowledge or the care to take care of young children he did not possess at the time. So as we went through negotiations in our divorce, we negotiated that he would get 6 months to be able to find a permanent place to live and the ability to understand how to care for a 2-year-old, a 4-year-old, and a 6-year-old. And he was okay with that decision because we put the best interest of our children at instead of the best interest of us. Yes, we could have said we're going to be 50-50 and 50-50 is how it is, but there were times where he would call me and I would have to show him the difference between Tylenol and Motrin and how to read the label because my son is taller than the average bear and how much medicine does he need. He didn't have the ability or had the knowledge because as the nurturing parent, like the former presenter said, I took care of all those pieces when we were married. This law requires domestic violence charges. I will tell you, as our marriage started to fall apart, there was a lot of disagreements. There was sometimes some holes in the wall, as my testimony says, but my children were sometimes present, sometimes weren't. But I learned later that that had an impact on my children, and my son got very aggressive in daycare. And it was something that wasn't brought to me, but it was something that was a result of our disagreeing. And it's not that we don't both love our children, it was we needed time to be able to provide the best living accommodations for our children, and that was the agreement. Senate Bill 2383 does not take the best interest of the child at heart. It says, I am going to presume that both of you are fit unless you have to come back with more filings and more reasons why you're not. And I think that in certain instances, and a lot of the times when we talk about family law, it becomes very messy and it becomes a case-by-case basis. But what I am cautioning the committee on is do not take a round hole and put it in a square peg. Do not say that the law is broken because certain outliers have concerns. Trust the years of this practice. We have talked about equal parenting for years. 2 sessions ago, we looked as an interim study in spousal support. And we took 6 months, we took a year to take a look at it, and every side weighs in. So if equal parenting is a concern, perhaps that becomes a study where we can take a look at it and look at all the experts. In certain instances, when you only have 2 or 3 people testifying, you may not get all of the components that could be a concern. My other concern about this is that it requires that when that child is with that individual, you have to communicate and education and extracurriculars and all these things. Well, our decree determined that I had the right of first refusal or parental responsibility when it came to education and health. The reason being is that I live in Mandan and my ex-husband lives in Bismarck. And we wanted to make sure that our children were in the same home, in the same school district, and there wasn't going to be a concern on where this child was going to go. When you look at health concerns, my question is this. So if my son is across the river, does he put his braces on? Or when he comes to me and I don't believe that there should be braces, do we, who's right in that respect? If my daughter chooses to quit playing basketball and my husband or I disagree, are we able to make that decision, or do we let them? Today my children are 12, 14, and 6, or 12, 14, oh shoot, they're 14, 16, and 18. Sorry. It's been a long couple of years. And they communicate with their father when they're with me, and they communicate with me 24/7 with the mode of social media, with the mode of telephone services. We put our best interests of our children in front, and we say that you can communicate with your dad when you're with me, and vice versa. We attend all of the ball games. We attend all of the concerts. We attend all of the everything. And it's because we're putting the children in place. In certain instances, that may not be the right answer, and I'm asking you to not require the court to make those presumptions without the ability to actually take a look at it. As I was looking through the bill, there are certain sections in there that if the child is an infant or if the child has a developmental disability, that we're going to take the best interests of the child at heart. So my question is this. So if my child is 12, then we split 50-50, but if my child has a disability, then we look to someone else to determine who has the best interest of the child? If the child is an infant, they automatically get to stay with the mother because that's, paternal instinct. But then I'm hearing testimony that he was denied the ability to be with his child after birth. So my question is you can't have it one way and not have it the other. Like we have to determine what is in the best interest of the child and keep it at that. The other component of this is that it's got the court must, and it's got a component of domestic or false claims of domestic violence that completely contradicts Senate Bill 2186 that we had a couple weeks ago. Bill, it says the court shall determine. So, I want you to take a look at a lot of these bills because some of them will contradict each other, some of them will have some adverse effects on this, and I want you to take a really close look at what really is in the best interest of the child. There are components of this that, can be workable, but at the end of the day, there's changes in family law here in the state that allows for mediation, allows for other things, parenting classes and parental discussions with counselors when children are involved that happen before all of this. And so the question is the court is trying to make some changes and allow for communications between both parents to determine what is best before it gets to a judge. And not all of these will get to a judge. But some of these outliers where they can't decide, those get to a judge. my decree never got to a judge. There were things we gave up, there were things we kept in line, but that I may not have agreed with, but at the end of the day, we took care of our children, and that was the best thing. And sometimes a parent has to do that. Perhaps they have to move. Perhaps they need to relocate closer to their child. Perhaps they have to take a different job. 10 years ago, I took a job staying at home because my ex-husband was traveling for work, and we needed to make sure that someone was available to shuttle my children because they couldn't drive. So that was a decision that I decided was in the best interest of my child to be able to be there for them. So I asked the committee for a do not pass on 2383.
Senator Murdahl.
Thank you, Madam Chair. And Ms. Hall, sincerely appreciate your testimony.
Thanks.
And to be honest and vulnerable in front of this committee where you usually come as a lobbyist. Are you familiar with the family law mediation program in North Dakota?
Chairman Larson, Senator Myrdal, that was established after my divorce was finalized, but it's my understanding that the court shall grant free mediation for up to 6 hours when there is a dispute, either after during the process or after the decree has been signed. So you're able to go to mediation for 6 hours for free.
Continue.
Maybe it's just me, but just there's a lot of, this whole bill is different than it was when it came to us a few sessions ago, because this one is based on the presumption factor. To me, a presumption factor just makes a lot more litigation available, and a lot more going to the court if you're going to use that argument. And also, it talks about alienation, when the court hasn't even set anything in statute about alienation in that particular case. So it seems to me there's just a lot of ambiguous stuff here that covers those people that I respectfully understand have struggled and had terrible stories. But it seems to me, maybe this is a comment, maybe a question for you. Family court is extremely overwhelmed. I think we heard that over and over again last session. Wouldn't that whole presumptive argument that could pop up constantly bring enormous amount of court hearings into play?
Chairman Larson, Senator Myrdal, members of the committee, as I was looking at this and some of those pieces in there, I did flag a couple of spots where I had concerns that litigation could increase, especially in the clear and convincing evidence to adjust a 50-50. That would take additional filings, that could take a domestic violence claim, that could take a lot of different things. And I think ultimately the goal currently in the system is to ensure that this is the smoothest process as possible, and to work together to try to find this. Yes, it may not happen, but when we're looking at some of these where it says the court shall do those things, those are the things that are going to be challenged. And I think that when you want to involve a child and you want to make sure that their transition is as easy as possible, it's not the child's fault that the parents can't get along. And what we're saying here is that we're presuming until there's actual evidence that both parents are fit. And I want to ensure, and I want to ask the committee to take a step back and say, is that something we putting the cart before the horse? Are we, if we cannot, if we cannot utilize a domestic violence order in those things, and granted, my ex-husband and I never had any of those issues, but when you are mandating the court to do different things, and you're going to increase litigation, you're going to increase filings, and at the end of the day, no one wants their divorce to be $30,000. They don't want to have it in the hands of attorneys going back and forth and racking up charges, because every time you talk to them, it's whatever their hourly rate is. At the end of the day, you want to come into this with an open mind and an open heart, and you want to support your children.
Senator Ludwig.
Madam Chairman and Ms. Hall, so your working relationship with your ex seems to be something that is tolerable, okay? Okay. In cases where that may not be true, let's say, for example, in fact, that neither one of the parents are maybe fit, okay? Mm-hmm. But one passes away. And so now you have just one parent for 1 or 2 or 3 young children. Is it best for that child, let's say, for example? Is it best to be with that parent or in a foster system? Now, there's no proof that there's no harm going on with these children, or there's nothing proven. Is it best that those children are with that last parent, in your mind?
Chairman Larson, Senator Ludwig, if something like that were to happen, prior to doing what I'm doing, I worked in human services, and I ran a couple homeless shelters, and we had a lot of things like that, where a family would come in, one parent, they would be overcoming addiction, they would be trying to make their ends meet. The other parent may not have been in the mix. They might have had a couple of parents in the mix. And one of those things was actually addressed in our stipulation, was that if something were to happen to my ex-husband or something to me, that a percentage of time would still be given to my family or his family. Because we looked into that. My ex-husband had some heart problems when my children were young. And so we looked at that situation. I believe that if one parent who has been the primary caregiver, for instance, and the other parent has been overcoming some concerns, I believe that family has a right to petition the court to say, I don't believe that they're fit. I believe that my son or my daughter was their primary caregiver, and I believe that the court should appoint that to me. And I believe that can happen. And I believe that those are the questions that have to go before the court. I don't think creating legislation that would require those things is again putting a round peg in a square hole, because we do have issues where there are processes, and I think the courts can determine who is the best parent for that individual. I will say that my current husband, his ex-wife was unfit to care for their 17-year-old. She was an alcoholic. She later committed suicide, and he received the parental authority even though he wasn't his biological father, because he had more of a relationship with my husband than with his biological father, and so the courts granted that.
Senator Paulson.
Thank you, Madam Chair. Ms. Hall, if your divorce had gotten to the courts, would you have wanted them to presume that you were a fit parent?
Chairman Larson, Senator Paulson, I believe that by the time my discussions and the process going through my divorce, by the time it had gotten there, the decision would already have been made between mediation or between communications between my ex-husband and I. So I don't believe that at that point that the court would need to make a determination.
May I continue?
Continue.
But if they had needed to make a decision at that point, would you have wanted them to presume that you were a fit parent?
Chairman Larson, Senator Paulson, honestly, no. Because I truly believe that if my children were better off with my ex-husband, then they should be with them. They should be with him.
May I continue? So, we have the presumption of innocence, and I think you and I would both agree that that's a good thing, right? That in America, we're all presumed to be innocent until we're proven guilty. Can you articulate why it would be appropriate for the court to not presume that a parent is fit?
Chairman Larson, Senator Paulson, I don't believe that the court doesn't have the authority to determine if a parent is fit, because I do know that a court does review and does decide whether or not equal parenting is warranted, and I do believe they go through the process. I just believe that as you go through a process of a divorce that could take 2 months, 3 months, 6 months, 6 years, it all kind of depends on the legality, that at that point, the case has already been made, and the court would rule based off of the facts that are currently in there. If something were to happen and it would go directly to a judge, I would hope that even in my situation, that a judge would deem whether or not if I wasn't fit to take care of my children, that he would put the best interest in of my children in the forefront of my wishes.
Any other questions from Ms. Hall? Thank you. Other testimony in opposition to 2383? We do have somebody online then. Hello? Mr. McLean?
Hello, can you hear me?
Yes.
Yes, can you hear me, Madam Chairwoman?
Yes.
Madam Chairwoman, members of the committee, my name is Jason McLean, and I'm a family law attorney at Parvey Larson McLean, PLLC in West Fargo, North Dakota. I've practiced exclusively in the area of family law since becoming licensed in North Dakota in 2004, and prior to that time, I clerked as a family law attorney in Grand Forks in 2000 to 2003. I'm also a licensed attorney in Minnesota and have practiced family law there exclusively since 2003. I'm a mediator in what I consider the most successful family law program created not only in our state, but maybe in the entire country, and that is the Family Law Mediation Program. I've been a mediator for them since 2020. I chaired the family law section of S-Band, co-chaired the S-Band Family Law Task Force with Judge Leah Ducharme, who now is a judge in Clay County, Minnesota. And both of those positions explored the very issues that we are discussing today. And it's with that background that I appear today and provide my testimony as a private citizen in unequivocal opposition to Senate Bill 2383. And I do want to touch on two things real quick from the questions that were just answered by Senators Ludwig and Senator Paulson. To Senator Ludwig's question, upon the death of a parent, by law, custody, residential responsibility, whatever we would like to call it, automatically reverts to the parent who remains living. In order to remove a child from that parent, the other family would have to start a third-party custody action, which are very difficult to do and do draw on fitness. That is the one area of this law that does draw on fitness. To Senator Paulson's question, with regard to presumption of fitness, that already exists. And I can say that because the law does not allow the court to look at a mother and a father and treat one differently. They are equal in the eyes of the law, and the focus is where it is and always should be, and that's on the children, not on the parents per se. As I read through this bill, I was drawn to the fact that the focus is on the parents and not on the children it claims to protect. Beginning with the presumption of fitness language found in Section 3, this bill takes what is in the children's best interest and sidelines it for a legal presumption. Senators, a presumption creates one thing and one thing only in this realm, and that is litigation. That's because the nature of a legal presumption requires a court and a judge who knows these parties for a short period of time and often sees them at their worst to make a decision as to whether or not the needs and best interests of the children will even get to be considered by the court. That fact alone, that we make the needs of an innocent child subservient to a parent's wishes and desires, should be disqualifying for this body and the body as a whole. However, there are several more reasons to reject this bill. Continuing in Section 3, the list of areas a court may look at to determine quote-unquote fitness will lead and require evidentiary hearings with clear and convincing evidence standards to rebut those factors. For example, what is a history of alienation? And how can there be such a thing when there is no court order to enforce, as stated in Section 3, Subpart 2C? What constitutes immediate family members interfering with a relationship, as stated in Section 3, Subsection 2B? If a grandparent wishes to see their grandchild overnight and the other parent feels slighted, would that be considered interference? The only way to answer these questions, and many others, will be to ask an already overworked and overcrowded judiciary to do so. As Chief Justice Jensen noted in the 2025 State of Judiciary message a few weeks ago, our district courts handle approximately 160,000 new filings and 20,000 reopened cases each year. That's 180,000 cases for a populace of less than 1 million. While not all of the civil docket revolves around domestic law cases, close to a majority of the civil filings in the past have been family law related. The continuing nature of child-related issues in family law also causes most of the reopened cases to fall within this area as well. Currently, our system is struggling to handle the volume of cases in family law. For example, one of my clients was required to wait nearly 4 months for an interim motion hearing in Stutsman County here just last year. Our rules actually require that a hearing be held within 30 days, but there was no room on the docket. Now imagine that every single contested residential responsibility case needs to be heard by a judge to answer the questions I posed just a few minutes ago. The backlog for families, for children in our state would be disastrous. That backlog means a need for more judges, more clerks, more staff, more everything just to handle increases in our family law courts that would not exist otherwise. Moreover, this bill would essentially neuter one of our state's greatest success stories, the family law mediation program. I would encourage each of you to contact Kathy Ferderer's office and look at the statistics of cases that avoid court because of that program. I would also encourage you to find somebody in your district that's been through that program before you consider voting to pass this bill. I would hazard a guess you will find that the people that use that program, that approach it with an open mind, will not need this bill, nor do the families in our state. However, if there's a presumption of equal time until the court says otherwise, the program loses its ability to help families. As a mediator, I cannot tell anyone what they should do or make them do anything that they don't want to do. I can't tell them what position they should take. I can't tell them anything that may give my sense of neutrality a hit. I can tell them to a point what I think a judge is going to do. But in a situation like this with a presumption, I don't know what a judge is going to do. And the only way to find out, as they say, when you're playing cards, you got to pay to see it. And that's exactly what's going to happen. That should not be our goal. Our goal should be trying to find compromise and ways ahead that avoid people going to court. That's what the goal in family law should be. Which brings me to something else that should be clear in this bill, and honestly, probably raises some questions for each of you. I've just told you this bill will increase litigation and create the need for evidentiary hearings in nearly every case that comes along. I've also told you I'm a family law attorney with over 20 years experience. That raises the logical question. Why would a family law attorney such as me oppose something that will make me more money? And senators, I'm not going to sit here and lie to you or try and tell you that money isn't important, because it is. But it's also not the driving factor for the majority of us in this profession. Believe me, if we wanted to make money as attorneys, there are far less stressful and far more rewarding areas that we could practice in than family law. Family law is difficult. It's hard. There are things that you are being asked to do for families that really some days make it very difficult to want to go to work. But we do it because it's best for those families. And yes, we represent our clients. But the best of us, the majority of us in this state, my colleagues, whether they're in Williston, Wahpeton, Grand Forks, and all points in between, they look at what's best for the children, because at the end of the day, we all fade into the ether. And what's left is those families, those parents, and those kids. It is not our job to make it difficult for them. And I don't think anybody in the judiciary or in the family law bar looks at it to do that. Now, if you do want to make us more money, though, this bill's the perfect vehicle to do that. Yet here I am telling you not to do so. No amount of money is worth the amount of harm this bill is going to cause to the families of our state if it passes. And lastly, perhaps most importantly, if you take nothing away else from my testimony as to why this bill should receive a do not pass recommendation, I want to draw your attention to the language related to domestic violence. Domestic violence is a significant problem in our state and our country. The majority of violent crimes, including homicide, can be traced to domestic violence. However, this bill at Section 3(2)D and in the rewording of the current domestic violence protection order factor, domestic violence best interest factor, seeks to limit what a court may consider when determining if a parent is quote unquote fit. It seeks to make it harder for abuse victims to be heard and for courts to protect children in those circumstances. This bill, as has been noted, does not even allow a court to consider a validly entered protection order for domestic violence as evidence of that violence. These clauses make no sense and are designed to protect the abuser, not the child. One other thing to note, many times people are arrested and charged with a domestic violence crime, and then they're pled out as disorderly conduct or something less. So even that conviction, which involved a domestic assault, would not trigger the provisions of this law. And that is when those are actually charged out or charged at all. There are several people that I am sure you could talk to in your own districts that have been victims of domestic violence that have had their cases pushed aside, not followed up on, and other things, because unfortunately, it is a silent problem that is a major problem, not only in our state, but throughout the country. Senators, I could spend hours discussing and dissecting and parsing each and every problem with this bill. I have not even discussed the myriads of problems within the abuse and neglect section of Section 3, or the fact that this premise has been roundly rejected by voters in this body for over 15 years on several different occasions. I understand we have limited time, and I cannot do that with you today. I would invite you to reach out to me and other people who practice in this area of law. I'd invite you to reach out to mediators in the family law program and to families where one parent has been the repeated victim of domestic violence. I would encourage you to listen to those perspectives and not just to parents who think they may have been wronged by other parents in the system. Our system in North Dakota is not perfect, and I'm not here to tell you it is, but it works more often than it fails. This bill is looking for a problem to solve that simply does not exist in our state. Now, that said, if you are looking for a problem to address, perhaps the place to start addressing is the number of family law cases that are left to languish because we do not have a dedicated family law court system in our state. North Dakota families, all of them, would be better served if the energies that came with this bill and House Bill 1242 were channeled into addressing the problem of access, backlogs, and the need for a family court system, not a presumption that does not treat families as the unique entities that they are. That would be the way to help families. This bill does not help families. For those reasons and many more I do not have time to share today, I respectfully submit to this committee that it should vote do not pass on Senate Bill 2383. I thank the committee for its time and consideration, and I'm happy to answer any questions that you may have at this time.
How long have we had the family law mediation program?
Madam Chairperson, I believe, I want to say it's going on close to over 15 years. I don't have the exact dates in front of me. I know that I have been part of it as a mediator for 5 almost, and I believe when I want to say it was like 2009, perhaps, that it was funded.
And
it's been around.
Has it grown?
It has. I believe it has, Your Honor, or excuse me, Madam Chairwoman, I believe it has. I will say that it has become very, very much a way to limit what goes on because, and just to give a quick aside, when I do my mediation orientations, I always tell people that it is a way for you to maintain control of your case because judges, while they will do their job and they do a fine job, in my opinion, they're also not going to be creative. And you are allowed to be creative when you are in mediation. That's the whole point, because you can reach an agreement, and if you don't, you can't use that against you in a court of law if you actually are one of the few cases that do go to court. And the reality of it is it keeps so many families from putting their children in the middle because the children don't have to be placed in the middle. It's not a competition. I've heard that term several times today. Family law is not a competition. It's never meant to be a competition. If you treat it as a competition, chances are there's going to be a winner and a loser. There are no winners and losers in family law. If you do it right, there's winners. If you do it wrong, there's losers. It's not a matter of winning and losing in this. And I know that strikes a little bit of a different chord for some people that maybe have been through this, and I understand that. But I've done this for 20 plus years. I cannot tell you my numbers of wins or losses.
Mr. McLean, Senator Corey has a question.
Thank you, Madam Chair. Mr. McLean, so in your testimony, I see that you referenced another House bill. I just wanted to say that I don't feel like that's a fair comparison to bring up a different bill in the bill testimony that's my bill. That bill has I had nothing to do with that bill, and I think there's vast differences in it. So I just wanted that comment.
Okay.
Madam Chairwoman, Senator Corey. Excuse me. Madam Chairwoman, if I may. Yes, please. Madam Chairwoman, Senator Corey. Senator Corey, the only reason I bring that up is because both contain a presumption of equal parenting time, or excuse me, equal residential responsibility as part of that. I meant not to disparage your bill in any way. It was more that was those two components are the same.
Senator Paulson.
Thank you, Madam Chair. Mr. McLean, I share your concerns with the domestic violence portion. If we set that aside for a second and just consider that not there, I guess I'm struggling with how a presumption of fitness on the part of both parents is negative for the child and how it prevents the utilization of the mediation system. I mean, fighting in court is expensive, right? And money is important. But if the parents know that on the other end of mediation that there is going to be a presumption that both of them are fit, wouldn't that encourage their honest participation in the mediation process?
Madam Chairwoman, Senator Paulson, that presumption already exists based upon how our law is treated. It doesn't need to be included in here because the presumption of fitness is not per se the problem. The presumption of equal residential responsibility is the problem. So when parents come into mediation, they will come in with what it is they are asking. And so the reason it chills the mediation portion of this is that unless a parent fits within one of the factors that is listed in Section 3, starting at line 31, subsection 2, through page, looks like 5, subsection, or line 3, unless you fit within one of those vague parameters, you are presumed to have equal residential responsibility. Fitness is a bit of a red herring because we already have that in place. Nothing in our law deals with fitness. We don't use that as a determination for parents. We will use it for determination when it comes to third parties because there's a higher burden constitutionally for a third party to take custody of a child than there would be for a parent. The only thing that fitness part of it is doing in this is creating litigation, because then a parent who doesn't want to have time equally, who for whatever reason, valid, maybe invalid, I cannot say for sure in every case, but somebody with a valid reason not wanting that person to have residential responsibility that's equal time, they have to go through and have a court determine by clear and convincing evidence under this statute that person is quote unquote unfit. Well, I will tell you, these things are not fit.
So, thank you, Madam Chair. Mr. McLean, I guess I'm just struggling with, if we're looking at the best interests of the child, from my perspective, it's really important for kids, as much as possible, to have equal input from mom and dad, to have both of them play a significant role. And it would seem to me that if you have as close as possible to shared primary residential responsibility, where the child has time with each parent, that seems like a good thing to me. What am I missing?
Senator, excuse me, Madam Chairperson, Senator Paulson, you're not missing anything, but those are two different things. So the equal decision-making responsibility piece of this that is found at line 15 on page 1 is a pretty common thing that courts do. There are very few cases that I can think of off the top of my head, absent abuse and neglect, where courts will not enter equal decision-making and require parties to be informed in that circumstance. When it comes to time, I will tell the committee the same thing I tell clients. Equal residential responsibility or equal time is a creation of family law courts. It does not generally exist in nature, and I will use myself as an example. My parents have been married for over 50 years. I was with them for 18 of those years. I don't know that I spent half the time with my father at any point in my entire time with him. In fact, if I had to probably hazard a guess, I would say it was probably akin to a 70-30 division of time. My father and I are extremely close. We talk to each other all the time. I love him to death. I didn't spend equal time with him, but that wasn't the point. The point was he was there when I needed him, and our law already provides for that. There are not cases out there in the majority of cases where people don't have time because you do have to show a clear and convincing finding to not give somebody parenting time. And that's a very hard standard to meet, and our judges take it extremely seriously. Mandating that everybody gets equal time does not solve the issues. It doesn't change things. What we need to look at is what is best for the child based upon the factors we have. And I will tell you, if there is one thing in this bill that I would say that I maybe agree with, I think the moral fitness factor probably should be removed because we don't use it. It's not a common thing to be used in our line of work. It doesn't refer to things that people necessarily agree upon that are moral. But the rest of those factors are some of the best factors that we have in the area, as found by the legislative study and the family law task force that went through a few years back. Our system, while not perfect, it works very well. It provides protection for families. It provides protection for children. It provides an openness that other states, some of them, just simply don't have.
Thank you. Any other questions? Oh, Senator Castaneda.
Madam Chair, Mr. McLean. Testimony earlier said that 5 states currently have something similar to what this bill is proposing. Do you, by any chance, know about these states and know why this has or hasn't worked in those states? Or am I way out of bounds of what you may know? And I understand if that's the case.
Madam Chair, Senator, I am not aware of that. I have never heard that. I do a lot of just sort of docket watching, for lack of a better term. The last time that I heard anybody in our area look at this was Minnesota last year when they did an omnibus change and they rejected this style of bill. I will tell you this bill has been around and floats around to a lot of different states. I can't say what other states have done or not done, or if they were even close to what we have, and this was a big change for them. So I guess I don't have a lot of background in that for you. I'm sorry.
Thank you. All right. Thank you very much, sir. Any other testimony in opposition to 2383? Any neutral testimony? Hearing none, we'll close the hearing on 2383. And committee, it's getting kind of late in the day. We're going to just hold off on taking any action on this particular bill until a later time, and we will see you at 9 o'clock in the morning.